This is appeal in the matter of Wathen-Fayed and Secretary of State for Levelling Up, Housing and Communities.
I've got a chair that is so low to the ground, I can't. But anyway, no, well.
It seems to be levelling down.
It's levelling down. It used to be. Good morning.
Is your Lordship content with
I think we'll go on. I hope you've been told that entirely for my convenience, I need to rise at 11:15 for half an hour. And I'm very grateful to everyone starting at 10. I think we've got more than enough time today to deal with the issues.
I'm sure.
But when we get to 11:15,
we'll keep a media on the time.
I'll rise and won't be before time sitting here. So. Right, there's another chair coming in, but we'll carry on. You have the benefit of the fact, Mr. Green, that we've read everything that's been submitted. I haven't gone through the whole of the key bundle, but certainly I've got an understanding of it. We're extremely grateful for the clarity of the skeleton arguments that have been put in.
I hope I can make it even simpler.
Yes.
That might be an ambitious claim, but I should probably introduce my learned friends first.
Yes, I'll let you get on with it.
I'm most grateful. My Lord and Lady, I appear obviously on behalf of the appellant, and my learned friend Mr. Darby appears on behalf of the Secretary of State.
Yes.
And Mr. Gately, KC, and Miss Davis appear on behalf of the Horizon Cremation Limited Party. The court will be aware there are basically two parts to the appeal. One is the Cremation Act and the other is the flood.
Yes.
I will be spending a bit more time on the Cremation Act point because it's a point of some public importance, and a bit less time on the flood.
We've clearly had supplementary documents in from the other two parties in the light of the substation action case.
Yes.
You haven't put anything in.
No, the short point on that, just to foreshadow what I'll say later, is substation action is obviously absolutely, well, it's obviously right because it's called a appeal decision, but it is actually on point in saying that an applicant for permission need not prove positively that there are no lower risk sites.
Right.
And that's what it's authority for. The 2 points of distinction here are, one, because this was a planning application on the Greenbelt, they had to do a site assessment of competing sites anyway,
right,
which is not the case in that situation. And so you have the available material should have been before the inspector. And secondly, there was a particular site, Farley, which has since been refused planning permission.
Yes,
because this one was granted.
Yes.
Which was a much bigger site and could have accommodated, for example, expansion and so forth, which this site could not do.
Yes.
And had a lower flood risk.
Right. Well, we'll get to this.
We'll get to that. Just so your Lordship knows,
yes.
we don't accept it's a silver bullet as claimed. So I should say that at the beginning.
No, well, that's helpful.
But I will spend less time on it because the Cremation Act point is a...
Well, that's the way the skeletons are cast as well.
Exactly.
The main focus is on the cremation.
Well, I think your Lordship's chair.
Oh my word! Shall we just do that? Never had this happen before. Oh, yeah. Thank you. I feel now altogether more in command. Yes.
I'm most grateful. My Lords, my Lady, can I first of all just get the court's eye in on what's actually on the ground, if I may, for a second, because it's quite helpful when we're referring to what it all involves. And there are effectively two iterations of the design, and they're found in the supplemental bundle. On page 28, and it's a rather smaller page number on these landscape ones.
Yes.
Now, there's almost illegible tiny writing on this, but the court can see the sort of olive green shaded area at the top
If I'm to hesitate to rise, I think Learned Friend may be looking at a different page, page 28.
Yeah.
Yes, the page we've got has got, it's certainly got small writing on it, but it looks,
Sorry, page 22, I
it
apologise.
looks like this.
Sorry, page 22, I apologise, I was reading for the middle page number. So I think it's the page number at the bottom left I should have been looking at.
The bottom right.
If there were a page number at the bottom right, then that would be right.
Oh, hold on a second.
So are you looking, you're looking at
Mine-
internal page 22, which I think is 32 of the bundle.
Yes.
I'm grateful. For some reason, mine.
It's headed Site and Landscape.
And
Site and
it's
landscape
it's a
section.
multicoloured
Exactly,
close up
multicoloured
of the
plan.
plot. Yes.
Yep.
And the olive green portion at the top is described as informal parkland.
Yes.
And then to the right, you've got memorial gardens.
Yep.
And then there's the ceremony garden, which comes into the informal parkland.
Yes.
And then the crematorium buildings are in purple.
Right.
And there's an arrivals space at the bottom of the crematorium buildings. And there's the service yard and access to the left with blue edging to it.
So people attending the building would arrive at the bottom of the plan, park their cars, walk through the little wooded tunnel area into the arrival space,
Exactly.
into the building, service takes place, then out through, presumably to the ceremonial garden if needed, and then back through the exit space back to the car park.
My lord, yes. And the arrival of the hearse would be in the middle of that.
Yes, hearse approach.
Exactly.
Yeah.
So that was the original design. And we can see, if we go forward to page 35, which should be have a big 6, building layout and development at the top of it.
No, it's got the big 4, site and landscape.
Oh, sorry.
Page 36, internal page, is it?
Internal 35, bundle 45.
Yes, for some reason this little bit of the bundle is not
Yeah.
numbered the same way.
Or 46. I mean,
Internal 35 on the right.
is that it's
Building layout and development, a
Well,
sketch.
Just got a sketch,
sketch,
of
yes.
building.
a sketch as opposed to 6 plans, which is the next page.
Exactly.
6:2 form massing in scale.
And the court will see drawn in pencil on the top right hand corner the edging of the service yard, just in outline where the service yard was going to be. And if one goes 2 pages further on, it's in pencil on the left hand corner of the bottom left illustration.
I'm lost. What page number are we on now?
Internal 37,
Yeah.
external 48.
So where's the 48?
External 47.
External 47.
So,
Okay, that's it.
so what's the pencil marking that you're drawing attention
It's
to?
the bottom left hand drawing, my lord.
Yeah.
And on the left hand side, you can see the left hand drawing,
Yeah.
top left of that drawing,
Yeah.
a little yard,
Yes. Service access.
service access.
Yes.
And if we go to internal 41, which I think should be bundle 51,
Yes.
finally, got it. Apologies for that. There's an overview plan, and the service yard is in blue on the left.
Yeah.
And if you take 1 page further over, we can actually see some of the content of what was going to be in the service yard there on the next page. There were going to be some photovoltaic panels for electricity, and the gas supplies were also going to be, I think, on the left-hand side there. And that was then varied and we can see it not hugely easily on the internal page 8 of this bundle.
So going back into
Go back to the beginning, if we may. Page 12. Apologies, I'm told it's page 12.
okay. I don't think it is.
No, it might be 10.
I think you are dealing with 8.
7.
So
9 is 19.
I do apologise to the court, it's not very helpful at all. My, the bundle, my copy of the
18.
bundle, starts, it's got the index at the front, and then at the bottom of the siting and planning of crematoria, it says page 4.
Right.
At the beginning, the very beginning of the bundle.
No. Yep. Yes.
But it's there, isn't it?
And if we go past that document, which goes up to, says page 7 at the foot of the last page of that document.
You've got a site plan drawing on the next
Yes,
page.
exactly.
Is that what you want us to look at?
And that's
The site plan with the
with the radii and the exactly.
Okay.
Exactly. So the two radius arcs are arcs from neighbouring dwellings, and the straight lines are distances from highways.
Yeah. So the complex has been snugly fitted in
It's been
to
very
the
snugly.
only available place that fits with the statutory wording.
Exactly. And the question is, is that all that should fit in,
Yeah.
or should it be more?
because you can see that the service yard, in fact, it says here carriageway for delivery. It's just
It's been
falls-
renamed.
Yes, but that's within the arc. I mean, that's one of the.
Well, it's actually, as your lordship will see, as we go over the page, we go 2 pages further forward. What they've actually done is they've renamed the service yard as carriageway access, and the shape of it is still there. What they've done is they've just moved the gas supply into the little area within the triangle a bit, and put the photovoltaic things elsewhere.
Yeah.
But the service yard's still there and still largely outside the area for those radii. So the 2 points that arise on the appeal are, and it's right that I should tell them what's in and what's out straight away. Access roads out, don't fall within section 5, prohibition. Car parking out, service yard in, and storage and or disposal of ashes in addition to the buildings themselves.
Storage and disposal.
Storage and disposal of ashes are in.
Yeah.
And just so the court has effectively how this all arose in almost only a couple of emails. Can I take the court to page 127?
You say that. Where do windows and doors opening fit?
Well, that's I'm coming to that on the buildings. There's the separate freestanding point on the fact that the windows and doors open out and opened out into prohibited area. And on that, there's a very short point of construction that the learned judge's reasoning on that is plainly wrong on its face. I'll take the court to it. He says that there's nothing to suggest that opening windows or doors would affect in any way the burning of human remains. Well, that is not the test. It's plainly part of the building, and it goes outside the triangle. So that's a freestanding point. It was a technical
Freestanding point from these categories that you're.
Indeed.
taking us
But
to.
just on the non-building parts, there are these 2 points.
But just out of interest, where are the windows and or doors that you say cross, when opened, cross the line?
On the
If you look at the plan, for
on
example,
the if they're on the bottom right-hand curve, definitely. There may be others.
No, but look at internal. Sorry, look at page 9,
Yes.
which is the slightly more detailed plan, which I think you referred us to.
Yes.
Yes.
And you can see the doors, for example, opening.
So it's the door opening into the exit space,
Yes,
and that's it, is it?
that's it. I think that the point is they don't mark where the windows open on the southern side. But if they are opening, because on the drawings you have marks for where the doors open, but you don't have marks where the windows open.
So if the windows opened on the inside, you wouldn't be making this point.
Or they're,
Exactly.
or they're sliding.
Or sliding ones.
Yeah.
Yeah.
So it's an easy point to get round.
It's an easy point to get round with a different design. Exactly. I accept that, my lady.
Yeah.
But, I mean, the point on that, if I may, my lady's absolutely right, it's an easy point to get round, but I will submit in due course the learned judge's reasoning on that point is illustrative of the way he applied Section 5, and which we respectfully say is wrong. So, going to...
Just a point of,
Sorry.
before you go on, sorry to interrupt you, Mr.
Sure.
Green. You very helpfully indicated what's in and what's out at the moment. Is that a refinement of the way it was put before the judge?
I think it probably is, Nadia.
Yeah, I thought
Fairly
it might
accepted.
be. I thought it might be because the way that I read the way with which it was put before the judge was basically everything, including the memorial gardens. In which case, it would be very difficult to build a crematorium anywhere.
Well, my lady, if I may say so, that memorial gardens, if they're used for disposal of ashes, are
That's
in.
that's a different thing.
Yeah.
It's ornamental. If gardens, just to be clear what our case is, if gardens are purely ornamental and nothing else, they're out.
Yeah.
Yeah.
If memorial gardens are used for the storage of disposal of ashes, they're in.
Well, there's a distinction that can be drawn between storage and disposal.
There is.
Certainly, on my reading, disposal would be in.
Exactly.
That's my certainly.
But
No,
if you could
current
go out and
understanding.
scatter the ashes into the meadows would be in.
Well, my lady, that is what the Act provides for and the regulations.
I know that's what you
Yeah.
say, yes.
Yes. And for good reason.
But in this case, as I understand the proposal, there's no disposal on this proposed on this site.
Well, my lord, what we say is functionally permanent storage in a cairn,
Yes, I know
a few
that's what you
centimetres
said.
above
yeah.
ground,
But
is disposal.
But in terms of
For these
scattering
purposes.
or burying, permanent disposal, there's no proposal for that in this.
There's no proposal for
Application.
interment.
Yeah.
If we can,
Yeah.
we'll come just to what
Very
is and is not disposal
Yeah.
under the statute. So the way it arose is that because of this, tiny site, the boundaries of the site and what was in and what was out were acutely an issue. Because anything could mean it couldn't be delivered. And their solution arose, if we start at page 127 of the bundle,
Of the main
of the supplemental still.
127. Gone.
Yeah, sorry, page 131, if I may.
I've got used to working on PDFs, and this is a very quaint way of proceeding, isn't it?
It is. Well, I'm very sorry. I think what I've got is a functional output of a different page number when the PDF was printed,
No
so
worries.
I really apologise.
Don't worry. It takes us back to the
It's the 30th of June email.
yes, Mary Davidson.
Mary Davidson,
Yeah.
and it's actually from Mr. Byfield to Mary Davidson, as we can see just below.
Yeah.
And it was about how to inter ashes. It's usually the second line. It's usually the case we want to give families the option to scatter the ashes directly on the ground in the memorial garden. However, at present, we're not aware of the level of groundwater on the site, so do not know if the aquifer noted by Surrey County Council will be affected by the interment of ashes, etc. And then explains in the third paragraph, we had a similar issue when building the crematorium at the Clyde coast of Scotland. Here the crematorium is built in an area where runoff feeds into a reservoir, so we agreed not to inter remains at all. Ashes are not buried below ground or scattered at any location within the site. Families are able to memorialise ashes on the site, but this is achieved in all cases above ground, in above ground secure cairns, with all ashes contained within watertight and secure polymer caskets. This arrangement works for both families who wish to have a cairn dedicated or in situations where they'd otherwise strew ashes on a memorial lawn. In this latter case, we have a communal cairn. I've attached a picture, and then they say the design would be different. And then 3 lines up from bottom, in the event that ashes are left on site without further instruction from families, they're stored in a secure unit within the building until arrangements can be made for the family or responsible funeral director to collect them. This arrangement has had no impact on the ability of the crematorium to meet requirements of local families. Indeed, it's proved a popular solution. 2 pages further on, which is page 135.
From 135.
That's not 2 pages.
133, there's a photograph of the
Communal cairn.
communal cairn design. So instead of being below ground, they're basically placed slightly above ground. And then over the page at 130,
Or even 134.
sorry, I apologise, 134. Bottom hole punch. I also note the observations of Ms Alda Song, Tambridge County Council Planning Officer, regarding the degree to which the application does or does not comply with the Act. In particular, the rules whereby a new crematorium may not be built within 200 yards of dwellings or 50 yards of the public highway. As you know, we're amending our plans so that even on the strictest interpretation of the guidance, we're in full compliance with the terms of the Act. However, Ms Song has raised the question of whether memorial gardens would comply with the Act. The guidance from the Department of Environment on siting crematoria, etc. And you can see there, by section 2, crematorium means any building, etc., everything ancillary. The department's advised that crematorium buildings, chapels, and parts of the grounds used for the disposal of ashes come within this definition, but not ornamental gardens, carriageways, or houses for staff. So that's what they're working on. And then if we go over the page to 135, says we will not dispose of ashes in memorial gardens here in Oxted and would accept a planning condition to that effect. Scattering ashes would not be allowed. Instead, mourners would be able to store ashes in the memorial gardens in suitably designed receptacles. Consequently, should families choose to remove ashes from the gardens at some point, this would be perfectly possible. As a result, we are compliant with the guidance because the memorial gardens are classed as ornamental gardens and not parts of the grounds used for the disposal of ashes. So that was the basis upon which they amended.
So is there a point that you make that although they use the word storage, it's effectively permanent
It is.
disposal,
Yeah,
particularly if there was a communal cairn?
exactly.
And although the word storage is used, they are disposing
Exactly.
of the ashes.
Yeah, and we can see from the regulations that disposal is not limited to scattering. If you decide to make the final decision as the resting place of the ashes,
Yes.
subject to the right to come back, of course, but might be there for 1,000 years. The idea that that's
So
storage.
if that's argument being put, which I understand it is, there's a need to contemplate why scattering and internment is on the wrong side of the line, but
This
it said that storage isn't.
doesn't make
What
sense.
is it about scattering and internment? Is it something to do with the contact with the soil and the?
Well, we simply say, my lord, it's both. It's very clear from the Act. I'll take the court to this in a minute.
Yeah.
It's very clear from the Act that there are two factors in the enactment of the 1902 Act. One was that people were appalled by cremation at the time, and the other was a public health point. Although I'll show the court in Price, the judge there observed that it was actually rather better for public health because the burning of the body meant there wasn't a risk of transmission of the disease of the deceased. So
Well, we'll come to that.
we'll come to that.
Yeah.
But so that is effectively what they decided to do. And then if we go forward,
They do make the point that storage may or may not be what you'd say permanent, because it's possible for families, if they wish to retrieve.
yes, but my lord, we respectfully say that the theoretical possibility that the family comes back and takes it away.
It might not be theoretical. I mean,
No, but
you can think of very, very obvious
Yes.
circumstances where a family might wish to have, say, the ashes of one parent
next to another.
next to another ultimately, but for a time
Yes.
stored.
Yes, but my lord, all I'm saying is that the fact that you can move it later, we respectfully say doesn't make any difference to the fact that it's disposal in the context of the operation of the crematorium.
Right.
They've got to have somewhere to put the ashes at the end of the crematorium process.
Right.
And that's disposal.
Yeah. Well, certainly that's helpful. In my head, I got storage as being a far more temporary holding of the casket
exactly.
or whatever it would be until someone collected it.
Yes,
So there would be a room in the building or whatever that might be, which probably happens anyway.
That does happen, and they actually say that. They say stored in a secure room within the building, pending collection or decision. But I mean, there's no doubt that sort of storage would be part of the process, and the room for it would be part of the building within the Act. So what we're doing is saying, well, that's temporary storage is in, disposal is in, but the storage that's much longer than temporary, decided on as if disposal, but might be changed their mind, that's the one thing that's out. And we say that's just absurd on the face of the way the Act works and the way the regulations work, which I'll show you, and I'll come to now. So the final email, just in case it's helpful, is 2 pages further on from the one I was on, which I think was 135.
That's 24th of July email.
24th of July. And that's just where they talk about the changes that I think I showed the court earlier. Reduction in the service yard area. That's actually, there's still a service yard. What they've done is they've renamed it on the diagram as access rather than the service yard.
And they brought, I think we saw that on the more detailed thing, they brought the various bits of kit inside the boundary.
To say,
yeah,
exactly.
Yeah.
So that's the point they've done there.
Yeah.
And it describes the pillars and so forth. And then they say on 137, over the page, as there will be no disposal of ashes in this area, it's not necessary for this garden to be outside the 200-yard zone.
Yeah.
So that's how they constructed their case.
Yeah. Thank you.
So if I could take the court now, if I may, please, to the authorities bundle. And beginning at tab 1. and I can confidently predict that the page number of the Cremation Act, first page, is page 3.
Well done.
It is.
We're on the up. We're
Yes.
levelling up.
Well, don't get too confident, Mr. Green.
I don't.
If we go wrong on the first page,
Exactly.
it's not looking good.
So this is the 1902 Act itself, and the court will be familiar with section 2. The expression of crematorium shall mean any building fitted with appliances for the purpose of burning human remains, and shall include everything incidental or ancillary thereto.
And those are the key words.
And those are the key words. And just pausing there, on a natural meaning, that's an expansive phrase. That looks like deliberately expansive drafting. It's everything incidental or ancillary thereto. So there were 3 opportunities there to narrow it. And over the page we've got section 5, and a point is made against me when we come to section 11 that the judge was construing section 5 and section 11 shouldn't matter. My lords and my lady, what I respectfully say is when you're construing a short act like this, you look at the whole act, particularly if you're seeking to determine the purpose and do a harmonious construction of the provisions together. And
Just out of interest, if that's the case, why haven't we been given the whole act?
I think there's very little left of it, my lord.
Well, I don't have sections 8 or 9 for a start. I don't know whether I'm uniquely dispossessed in that respect.
No, we haven't got 8 or 9.
I don't think there's anything relevant in them.
I don't think there is either, because I had a look, but I couldn't understand why we weren't given them.
Well, I apologise. We'll check to make sure and circle back, but it's a completely fair point. When we look at section 5 itself makes provision for no crematorium, as defined in section 2, to be constructed nearer to any dwelling house than 200 yards, except with the consent in writing of the owner, lessee, and occupier of such house, nor within 50 yards of any public highway. That's the second one. And there's a third one, nor in the consecrated part of any burial ground of any burial authority. But that's nothing to do with public health at all. And so the argument that you disregard section 11, which is clearly addressing religious sensibilities and ensuring that there is no obligation on an incumbent to perform a funeral service before, at or after the cremation, that section 11 is uniquely directed to the public sensibilities and not to public health at all. And section 5, by including the third limb of the prohibition, it also embraces that purpose, which we say is important. Because the prohibition on building a crematorium in a consecrated part of the burial ground of any burial authority has absolutely no bearing at all on public health.
Well, if the neighbour can consent, it also suggests it might not have anything to do with public health.
Well, that was a point we've made in the skeleton, yes, and that's a second and additional point. It'd be bizarre if you can consent to public health risk in your last week in the house as your parting gift to the incoming tenant or purchaser. So it isn't. There may have been some public health element to it. We don't suggest that there's public health plays no part in it. But the premise of the enactment is pretty clear from what happened in Price's case. The horror at burning of remains and the desire to regulate it. Parliament had a go in a bill that didn't become law, as we'll see in Guy, that Lord Newburgh recites that in Guy. You can see how that works. So the short point is there. Number one, it's quite wrong to confine the purpose of this act to public health, which is, we say, what the learned judge did, and I'll show the court that in a minute. It is true that introducing it linguistically, he said it was the primary purpose was public health. Although when dealing with section 5, he said it was public health. But we say by not having regard to anything else, effectively got it wrong. Yeah, his definition was either materially incomplete or just flat wrong. And if one is going to undertake a purpose of construction of a statute, the anterior exercise of correctly identifying the purpose of the statute is absolutely essential.
Which is why the long title is important.
Indeed. And the long title regulates the burning of human remains and to enable burial authorities to establish crematoria.
Not to disable local authorities from establishing crematoria.
No, lady, but what it was doing was setting the bounds within which that was to be done.
It's a facilitation act and a regulatory act.
Indeed. And what it was doing
It
was...
is regulating, is it not, the burning, not the disposal.
Well, milady, we respectfully say that's not, with respect, correct. We say that it was regulating the entire operation of a crematorium and striking
That's what it says, though.
Well, we respectfully suggest that the express provisions of the Act are rather important when one comes to try and find what the long title is doing.
Well, just on the similar too, I mean, unfortunately, I don't have the remainder of section 7 either. Headed regulations as to burning. Secretary to make regulations as to the maintenance and inspection of crematoria and prescribing in what cases and under what conditions the burning of any. That's as far as I go.
We're missing
Yes.
two sides, aren't we?
But I assume that the Cremation England and Wales regulations 2008 are
Made.
pursuant to that
They are.
act,
They are.
and they include, as you've put in the bundle, provisions in relation to the disposal of ashes.
Precisely. So the disposal of ashes is regulated specifically by regulations made under this Act.
But what I was getting at is, I don't know what the extra words are that, as it were, authorise the making of regulations as to disposal of assets.
Yes.
Of ashes.
Of
Sorry.
ashes. Yes.
Sorry, wrong type of course.
Exactly. I think that was the last.
That was the last time we met in
Yes.
court. Yes, exactly.
We will provide the full Act. I'm sorry that they weren't there. We tried to pick out the most obvious thing.
Okay, but it would just be interesting
would.
to see the virees, the phrase that gives the virees to
Exactly.
a provision about disposal of ashes.
Yes. Yes, indeed. So the court's got my point on section 11. Not about public health at all, about Christian sensibilities. So we respectfully say that Parliament was striking a policy balance in order to enable crematoria to be established. So it was facilitative in the sense my lady notes. And it was regulatory in striking a balance about this being done at what Parliament saw as a reasonable distance from a dwelling house or a highway. Those are the direct points in relation to the express provisions. If we go, just before I come to the regulations, if I could just take the court through the legislative genesis that follows on in the 1935 Act, which is in tab 2.
Yes.
And if we go forward to page 8, the court will find section 64(1), the foot of the page.
So this, for those who haven't got it in front of it, this is the London County Council.
It is. And this is the central London County Council, but the London County Councils, not the outer London ones. We'll come to those in a minute. And section 64(1) says, in the application of section 5 of the Cremation Act to a borough council, the restriction imposed by that section upon the construction of a crematorium near to a dwelling house shall not apply with reference to any dwelling house situate at a greater distance than 100 yards from the site of a proposed crematorium, nor to any new dwelling house.
I'm so sorry, Mr. Green. Can you give me the section number again? Because it doesn't.
Sorry, section 64.
At the bottom of page 8.
At the bottom of page 8. It's in the margin. It says consents under section 5 of the Cremation Act.
The last 2 lines on page 8.
Not on my page 8, it isn't.
Oh, I can see. So it's section 64. Have you got? No.
No, my page 8 is.
Internal page 36 of the Act of Parliament.
Oh, wait a minute, I've got 2 page 8s. Sorry, Mr. Green, it's my fault. I've got it now, thank you.
Most grateful. It's the bottom of, so it's section 64.1.
Yeah.
And it's varying the distance to 100 yards and excluding any new dwelling house, which would be very surprising if it was a public health matter. And if we go on to page 9, and I think this is a slight refinement on how I put it in the skeleton, so I want to get this right for the court. In subsection 2, 64.2, just above where section 65 starts, it says the expression site of a proposed crematorium means the land which is proposed to be covered with a building intended to be used for the purposes of burning human remains. So what they do there is they confine it to the building. So excluding the service yard and memorial gardens, we say. But if it is only the building, that would be completely unnecessary. And one would not...
Your submission is, just to make sure I'm clear about this, that Parliament, by enacting this particular act, has changed the definition to avoid the ancillary and incidental parts of the statutory definition in the 1902 Act.
Exactly. It's actually done 2 things, Milady. It's reduced the distance to 100 yards, excluded new dwellings, and made it just what we've got in the triangle, basically.
The land covered with the building.
Land covered with the building.
Yeah.
And if the judge was right, or close to right, that wouldn't be necessary. We respectfully suggest. And then what we then see in the 71 Act, the language is arguably quite helpful as well.
You say it wouldn't be necessary, but it might clarify the point. It might make the point.
Well, this is a change being introduced to make it easier to build them. I mean, if it was a matter of clarity, the section 5 would be amended for everyone to say that. And it wasn't. So what they do is they recognise that London's very pressured. They say, look, there's 100 yards, and it's only going to be 100 yards from the actual building itself, not from everything ancillary and incidental. So that's the change that's effected by primary legislation. And we then see the equivalent drafting in the 1971 Act, which is in tab 3.
This is the Greater London.
The Greater London Act. So just going forward after the title page onto page 11, we get the first page and the second recital under whereas at 2 it says it is expedient to extend to the councils of outer London boroughs and to certain other authorities the provisions of section 64 consents under section 5 of the Cremation Act and of the London County Council General Powers Act 1935, and otherwise to amend the law in relation to the provision of crematoria Greater London, And if we go over the page, on the right-hand side, section 7 says, 7.1, in its application to a crematorium constructed or proposed to be constructed on land in Greater London by a Greater London Burial Authority, section 5 of the Cremation Act 1902 shall have effect and be deemed always to have had the effect, as if for the word crematorium there were substituted the words building fitted with appliances for the purpose of human remains. So that makes the change being effected by primary legislation even clearer than was apparent in the 1935 Act.
Those are the same words, aren't they, that appear within section 2 of the 1902
Exactly.
Act, but it doesn't include, shall include everything incidental and ancillary.
Exactly. So what they're trying to do, they recognise there's not going to be space for memorial gardens and so forth as easily found in London. And they therefore strike a different legislative balance in the context of balancing the need for crematoria with the respective sensibilities.
Yes, and it is, that's exactly the word I had in my mind. If the primary purpose isn't public health or isn't necessarily public health, then what is it? It's certainly in Victorian times, it's public sensibilities.
Yes.
You wouldn't want one of these bang up against the boundary of your property, rather than you might be harmed.
No.
And what the public health danger might be if it's 200 yards, 300 yards, 100
or 50 yards.
Or 50 yards. I mean, it's
99
very hard to
yards.
understand what the public health danger
Exactly.
was even 120 years ago.
And it's for Parliament over time, our submission.
It just didn't feel right to have
Exactly.
this activity taking place very close to someone's home.
Exactly.
Yeah.
That's all it was, really.
Yeah.
And we respectfully say that it follows from that it's for Parliament to set that, to strike that balance in primary legislation from time to time, as Parliament's appreciation of the balance of those sensibilities against the needs changes. Yeah. And that's what happened in 35 and 71.
Yes, but if it was radioactive, you wouldn't be making these exceptions.
Exactly.
Yeah. And having the consent provision within the
Precisely.
Act. Yeah.
So we respectfully say it all sings with one voice. Yeah. And we respect the learned judge was wrong in his appreciation of that aspect of the legislation.
And do we also need section 7.2 as well?
Yes. So that basically then...
Same sort of point, it's the same point.
It's the same point again, and it just substitutes the words and makes sure it feeds through into the other aspects of the legislation. But it's the same point again. So it's confining, it's narrowing the word used, the buildings, instead of used for, which is a wider term than fitted with, because the actual building fitted with the appliances themselves, you could theoretically confine that more narrowly. So it's trying to make the statutory language narrower in a number of respects. And it recognises the difference between used for and fitted with in subsection 2b.
Yes.
And then we come to the Cremation England and Wales regulations, 2008 in tab 4, and it's regulation 30, regulating the disposal of ashes.
And in fact, section 7, if we had it complete, it will read, we will see, it's prescribing in what cases and under what conditions the burning of any human remains may take place, and directing the disposition or interment of the ashes.
Yes. So it doesn't use disposal as a word, but it uses disposition, which is a finesse on the verb.
Yeah.
May have a slightly different meaning.
Regulation 30.
That's Regulation 30, pursuant to Section 7. And so the structure is interesting. Regulation 31 provides that subject to paragraph 2 and Regulation 37, 5 and 6, after cremation, the cremation authority, A, must dispose of the ashes in accordance with the applicant's instructions for ashes, or B, in any case where the applicant does not give instructions for ashes or where the ashes are not collected in accordance with those instructions, may dispose of the ashes in accordance with paragraph 3. So the 31A is an obligation to dispose of the ashes in accordance with the applicant's instructions for ashes. And if the applicant says, I want them stored in the memorial garden, we say that provision bites and there is that obligation. And that is a matter that's in issue because it is contended that application doesn't bite. I'll come to that in a moment or two. And then it says B, so you've got the primary obligation to dispose of the ashes in accordance with the applicant's instructions. We say dispose there includes keep them in the memorial garden in a sealed container, or scatter them, or inter them. Those are the options available to the applicant. And then 31B, in any case the applicant does not give instructions or ashes are not collected in accordance with those instructions. So that's if either no instructions or where they say we'll collect them and they don't collect them. They may dispose of the ashes in accordance with paragraph 3. And there's a small drafting point here, my lords, because 31B says may dispose of the ashes in accordance with paragraph 3. But when we look at paragraph 3, that appears to be mandatory.
It must mean may only, mustn't it?
I think it must mean may only. Yep. There may be I think there's probably a temporal element in the use of the word may that may have informed it, I don't know, but I think it must mean may only. Because 3 says...
Must.
Yeah, where paragraph 1B applies, any ashes held by crematorium must be decently interred in burial ground or in part of a crematorium reserved for the burial of ashes or scattered there.
Well, that's the way in which they are disposed of, but that rather suggests to me that disposal in that sense means interment rather than keeping them somewhere.
Well, my lady, I agree. These are the options on disposal in the absence of instructions to the contrary.
Yes.
Or where they've not been picked up. So there's no obligation.
To dispose of them at all.
Well, no, I would respectfully suggest it'd be very surprising where someone gives no instructions or says I'll pick them up and doesn't, that you would be obliged to hold on to them in a sealed container.
Well, you wouldn't be obliged to, but I think the point that I'm making is that there is a clear distinction being drawn between what you do to dispose of them, which is in accordance with subpara 3 to inter them in a decent place, either in a burial ground or part of a crematorium reserved for interment, or scatter them in such a place, and not disposing of them at all, which might involve keeping hold of them.
Well, my lady, just with respect, I think the distinction is that the disposal of the ashes, the obligation in 31A, relates to disposing of the ashes in accordance with the applicant's wishes, instructions. We say, if the applicant says, I want them left in a jar
above ground.
above ground, that is a form of disposal and instructions which you're bound to follow by 31A, we say.
I mean, who do the ashes belong to?
Ah,
Well, I don't think there's any property in the ashes.
executors, no.
I'm not.
It would have to be the executives.
I mean, this is to
Yes.
enable crematoria to not have to indefinitely hold on
Exactly.
to something that they don't own. I
Exactly.
mean, we can be reasonably sure that they don't own the ashes.
Yes. Exactly.
Query who does.
Yes.
It seems to be the applicant's right to dictate how they should be disposed of.
Yes.
But if the applicant doesn't do something,
Yes.
then to avoid the crematoria having to indefinitely
Hang on to them.
hang on to them,
Exactly.
they're given certain rights.
They can inter them or scatter them.
Yeah.
Yeah.
Yeah. But that's because they're left with either no instructions
Yeah.
or the arrangements for collection haven't been honoured.
Yes, and the point is that the crematoria doesn't have any right, absent this, to do anything, or at least it wouldn't, on the face of it, have any right to do anything with it, with the ashes, because they're not its property.
Agreed.
Yeah.
Right.
Yeah.
This is a default position.
Yeah.
Rather than one of right. Yeah.
Yeah.
Yes. So it's empowering them
Yeah.
to do something with something that definitely doesn't belong to them. And you can see that's really what that section is directed to functionally, because if you look at 4, it says, in relation to ashes left temporarily in the care of the cremation authority, the authority may not inter or scatter the ashes unless the cremation authority has made reasonable attempts to give the applicant 14 days notice of their intention to do so.
Yeah.
So that's a similar provision.
And there's probably a definition of applicant somewhere.
My lord, there is, and we can get that if it's helpful, but I think functionally it doesn't matter at the moment.
No.
Who fills in the form?
So what we say is important is that if the system in a particular crematorium is keeping them 1 centimetre above ground rather than 1 centimetre below ground, that does not mean that 31A does not apply. Nor does the fact that you could come back later and say, I'd like to retrieve it from the can. That doesn't mean that 31A doesn't apply, so as to require the crematorium to dispose of them in the way that you've said for those purposes. So if you go to a crematorium and you say, I want the ashes interred, please, 1 centimetre below ground, or whatever it is, the crematorium is obliged by 31A to do what you've asked. And we say, equally, if the crematorium offers the possibility of storing them 1 centimetre above ground, the obligation remains the same on the crematorium to honour and respect that choice as to disposal.
Presumably the crematorium won't agree to do the cremation at all unless the instructions which it receives are ones that it can comply with.
Exactly. Yeah. Exactly.
Before we leave 30 sub-regulation 3, different point, but the phrase there about must decently inter in part of a crematorium reserved for the burial of ashes, that must be outside the building.
It is, my lord.
And so that's showing that
the lordships are lighted upon
there
the
we are.
bit
Well,
that I've double highlighted.
well, I've put a box around it, and so if it was in doubt that the phrase crematorium included in part the land, if it's used for this purposes,
Yes.
that's not in doubt then.
It's put beyond any doubt by that fact, as your lordship said, because so the memorial, where a memorial garden, I think the distinction between ornamental garden and memorial garden is memorial garden is where the ashes can be interred or scattered,
Yes.
or here stored, and ornamental has no.
It's just a
purely to
peaceful,
look
just
at.
a peaceful
It
place.
looks nice.
Yeah.
So that is that. I'm keeping a beady eye on the time.
Yes, we're all right.
If I can just take the court very briefly in passing. In tab 5, we've got the Price case to which Lord Newburger, the Master of the Rolls, referred in Guy, and at the bottom of page 26, which is internal 255 of the report. Five lines up on the right-hand margin. I do not think, however, it can be said every practice which startles and jars upon the religious sentiments of the majority of the population is for that reason a misdemeanour at common law. A statement of such a proposition in plain words is a sufficient refutation of it, but nothing short of this will support the conclusion that to burn a dead body must be a misdemeanour. As for the public interest in the matter, burning, on the one hand, effectually prevents the bodies of the dead from poisoning the living. On the other hand, it might no doubt destroy the evidence of the crime. So that was the point I was making earlier, my lords, about the, just from the public health perspective, in the run-up to the enactment of this Act, it was regarded as a benefit to public health that it would prevent the dead from poisoning the living.
Yes, and the mischief was identified there as being the startling or jarring of religious sentiments,
exactly,
rather than anything to do with health.
Exactly. And my lord, what we see if we go forward to tab 7 in Guy is a rather ambitious submission, I think.
I mean, the last, just out of, before you pass on from Price, I mean, the last paragraph of the report is, again, gives you a sort of lead into the sensibilities point as it's become referred to, isn't it?
Exactly.
Sorry, where are you?
The last
paragraph.
On page 256 of the report.
Yeah.
This brings me to the last observation.
Thank you.
Yeah. And it, about halfway down, to burn a dead body in such a place in such a manner as to annoy persons passing along public roads and other places.
Yeah.
They're no doubt a nuisance.
Yeah, can we imagine?
So it's all entirely consistent, we say, with the express provisions ultimately made in the Act and the primary purpose.
Offensive to sight and offensive to smell.
Yeah, there's also that.
That's what's actually said, isn't it?
Yes.
Yeah.
And then there was an ambitious submission made by Mr. Swift. I think it's Mr. Justice Swift when he was at the bar, I think. Yes. At page 106 in Guy, which is in tab 7. And it's at paragraph 28. It begins. And just so the court, before we look at paragraph 28, you just look at the top of page 107 first. It was quite a bold submission. He was saying, if prohibiting publicly visible cremations was intended by the legislature. So he was saying that the purpose of the Act was to make them invisible. And that is not, that is, we respectfully say, going too far. The point of the Act was to put them at a respectful distance, having due regard to a balance struck in primary legislation between sensibilities and desirability, as my lady says, of facilitating the building of crematorium. So, going back to paragraph 28, I turn to Mr. Swift's third argument, namely the purpose of the Act was to prevent the public seeing the cremation. I accept that the passing of the Act may well have been triggered by the direction given by Mr. Justice Stephen to the jury in Price, which we just looked at. In that case, the jury was directed to acquit the defendant, etc. And then a bit further down between F and G, in the course of his learned and interesting discussion, at page 255, he referring impliedly to cremations, said that not every practice which startles and jars upon the religious sentiments of the majority of the population is for that reason misdemeanor upon law, etc. And then, which is exactly what we just looked at, and then Lord Neuberger then goes down halfway between G and H, looking at the 1884 bill to prohibit public cremations on the ground they're contrary to public decorum and decency. Yeah. And then 29, I do not consider the decision in Price's case and the purpose of the 1884 bill were enough to establish one of the purposes of the Act was to ensure cremations were performed so as to be invisible to the public. Because invisibility is taking it one stage further. And that's not our case.
And that was one of the points in Guy, wasn't it? Because what Mr. Guy wanted was to do something in the open.
Exactly.
Yes.
So the sunlight to fall on it.
Yes.
And Lord Neuberger balancing, and there were human rights issues at play as well.
Yes.
And making a very sensible construction of the Act. It was there was an element of public health perhaps, but balancing the sensibilities, the Act sets the limits, is what Lord Neuberger says, of the protection in relation to privacy. And we see that at 107, letter B. So halfway between A and B, on the right-hand margin, Section 5 directly addresses the issue of proximity of cremations to dwellings and highways, and if it was intended to address the issue of privacy of a cremation, rather than public health or privacy of residents and risk of congestion, it represents the limit of the protection the legislature thought it right to provide. So that's really, my lords, my lady, the foundation for what we say is Parliament striking a balance, a legislative balance in primary legislation between the sensibilities and facilitating the building of crematoria. And then just parenthetically at E to F, on those particular facts, Lord Neuberger was saying, left-hand margin, the word further, rather than intending to give the word building an artificially narrow meaning, seems to me it's much more likely the legislature would have anticipated the visibility of a cremation being dealt with in regulations made pursuant to Section 7 of the Act. So, any narrowing of any specific provisions of that sort could have been made under regulations if invisibility was going to be a specific requirement. And over the page on 108, paragraph 35, in the light of these factors, I consider there's no reason not to give the word building its natural and relatively wide meaning in Section 2 of the Act, as discussed above. That the noun which one might primarily use in ordinary conversation to describe some of the structures mentioned in paragraph 25 would not be a building is nothing to the point. The primary way most people would describe the structure in which they would live would be a house or block of flats. That doesn't mean that house or block of flats is not an ordinary language of building. That really goes no further than just adopting a natural meaning of the words used and not unnecessarily confining general words in the statute. So those are the key authorities in relation to the proper construction of the.
So in terms of your appeal, you say that the judge was wrong to indicate that the primary purpose was the protection of public health. What do you submit the purpose of the legislation was, if it wasn't primarily public health?
The primary purpose was to strike that balance between public sensibilities and the need to facilitate crematoria in a sensible place. I mean, that's a function Parliament does the whole time. It's a policy question for the legislature, and it's not one to be finessed by the courts, particularly where we can see Parliament itself changing the definitions where it judges the balance should be struck differently.
Because the need is more
because
pressing.
the need is more pressing, and people live much closer together anyway in central London and then latterly out of London.
Yeah.
And so Parliament strikes the balance differently. But that's expressly contrary to the court changing the rules in some way.
And also, one anticipates that public sensibilities change. What was outrageous in the 19th century was beginning to be tolerated at the beginning of the 20th century, but now may be thought to be commonplace.
Yes, and it may be that Parliament takes the view that it's time for a change, but that's a legislative change.
That's not our business.
Exactly, that's our short point.
That might.
Is that a convenient moment?
But it seems like a junction.
Yes, it is.
So, how, in terms of time, how are you doing, Mr. Green?
I'm doing reasonably well. I'm hoping, even with the 40 minutes gap, to finish before lunch.
Yes.
If that
I think that's
strikes a suitable balance, gives everyone plenty of time to.
Not surprising, and that obviously gives time for others and then a response. Good.
Most grateful.
Well, we'll be back ready to sit at 1:45.
Most grateful.
Thank you. I'll rise.
All rise if able.